Hello, good citizens. My name is Dan. Welcome back to part 4 of the Victoria Crown Prosecutors Lies and Crime series. Warning, this video contains language not suitable for all ages. Viewer discretion is advised. So in part 3, after a sleepover at the Victoria Police Department and being in custody for 26 hours for my benefit and without a bail hearing or any information brought before the court on record, Judge Jennifer Barrett decided to hold me in prison over the weekend because the court time had ended for that day. Even though I was in a court cell all day in leg shackles, Crown Prosecutor Melissa R. Murray also thought I would benefit from an entire weekend in prison instead of having a bail hearing on a busy weekend. So, according to Judge Jennifer Barrett and Crown Prosecutor Melissa R. Murray, for my benefit, I get to have a bail hearing the following Monday, first thing in the morning. That will happen sooner rather than later without delay. And on my 5th day in custody, just after 3 p.m., with barely an hour left for court time that day, I finally get a bail hearing. Now, normally in a bail hearing, the prosecutor has to tell the judge the allegations, and the judge always agrees, and the prosecution of the accused moves forward. However, when an accused who is on bail conditions and is before the court for breaching those bail conditions, the accused is now in what's called a reverse onus position. What that means is it's up to the accused to prove that they did not breach the bail conditions, not the prosecutor. Do you think, after filming Kate Dutton at their office and getting it on the court record that they disclosed Mr. Poo's address to me, and after making fools of them in court on the record the previous week, that I will be getting a fair bail hearing? Here is that hearing. But please be advised, what you're about to hear is a very one-sided story from the prosecutor, Lauren T. Phipps, whose intention here is to mislead the judge and to say anything that will convince the judge to hold me in prison. I'm also going to pause this periodically to narrate and bring up evidence. Here it is.
Your Honor, Phipps, first initial L for the Provincial Crown.
Your Honor, for the record, Roland Kachmar. I appear as duty counsel this afternoon and this is Dan in custody, and it's for a judicial interim release hearing, Your Honor.
Your Honor should have 2 informations before you.
I do.
This is as my friend Mr. Kuchma indicated, this is the Crown's application to revoke bail on, and to detain in the first instance on. The Crown relies on the secondary ground analogies and the accused is in a reverse onus situation by virtue of 515 subsection 6c of the Code. I'll begin first by relating the circumstances of, or just before I launch into that I'll advise Your Honor that the circumstances of the lead offense are not that serious and that the Crown characterizes the second information as an incidence of, broadly speaking, witness intimidation, and it's really the second file that is the reason why we seek the accused's detention today. But with that preface, beginning chronologically with the first information, the allegation is that on the offense date of July 2015 at approximately 11:30 am, the complainant on that occasion was walking his dog in the vicinity of the block of Southbound Street near Uphill Avenue in Victoria, British Columbia. The accused, Dan, resided in an apartment building adjacent to the sidewalk where the complainant was walking his dog. The dog defecated on somewhere around the sidewalk or yard of the apartment building, and the accused yelled down from his floor residence to the complainant, Mr. Poo, telling Mr. Poo to, quote, pick up the fucking shit, end quote. Mr. Poo stated in reply that he didn't have a bag, having used his bag earlier in the dog walk, and the accused is alleged to have said, I don't fucking care. Pick it up. The accused continued to shout at the complainant.
So what Lauren T. Phipps is telling the judge here is what Mr. Poo told the police. So this is just one side of the story. So what the judge is actually hearing here isn't what actually happened.
The complainant began walking away with his dog. A couple minutes later, while walking his dog, the complainant was struck from behind by the accused with a closed fist on the right side of the face.
So this very one-sided story that Lauren T. Phipps is telling the judge is just perfectly tailored so that the judge hears that all this person is is a victim, even though he broke a bylaw in what he just told the judge, and also what Lorne T. Phipps is intentionally leaving out of this story, this one-sided story, which Mr. Pooh wrote a statement to police about, is that even though he claims that I snuck up behind him and sucker punched him out of nowhere, Mr. Pooh had a cell phone in his hand the whole time. Yet he never used it to call the police or 911 to report that someone snuck up behind him and sucker punched him out of nowhere when he wasn't expecting it. Lorne T. Phipps is actually intentionally leaving out the fact that Mr. Pooh only called the police after I told him I was calling the police on him. He waited 5 3/4 hours to call the police non-emergency number to claim that I assaulted him. Does that sound like the actions of someone that knew the police were called on them for something that they did that was criminal? Or does that sound like someone who was walking their dog and someone snuck up behind them and sucker punched them in the face out of nowhere when they weren't expecting it? These are very important facts that Lorne T. Phipps intentionally left out in order to mislead this judge.
The accused, Dan, then ran back to his building that he resided in. Within minutes of this incident, Dan called the police, alleging that there was a man threatening him on his property. However, he refused to answer any questions.
Sorry, who phoned the police?
The accused phoned the police.
Thank you.
Mr. Phipps has also seemed to have spun up a little story about me leaving my building to assault Mr. Pooh and then run back to my building and then call police, which is odd because that never happened. So this is another thing that's purely fabricated by the prosecutors.
Alleging that there was a man on his property threatening him. He, however, refused to answer any questions regarding that incident but demanded that the police be sent and hung up. The police attended the accused's residence within 7 minutes of the call. He answered the buzzers. He was extremely abrupt with police, advising that they were no longer needed and to leave. The police understood the residence to be associated with a female, not with a male, and were keen to speak to Dan face to face to make sure everything was okay, given that he'd recently made a 911 call. Another occupant of the building let the police in. Dan refused to answer his door and yelled at the door. Through the door to police.
So what Mr. Phipps has done here is he's left out intentionally the fact that the police refused to ID themselves. It's been well documented that I spoke to a police sergeant about this on the day of, and I made a lengthy complaint through a lengthy complaint process about the police refusing to ID themselves at the door. That's why they weren't let in. That's why I never opened my door for them. All well documented, but this is all intentionally left out. All the stuff about the police threatening to break down my door and them having no authority to do so, totally left out. And then he says that the police understood that the residence was associated with a female. That's not true, because the residence was not known to police. What's in their computer system is what they relied on, and they are fully aware that what's in their computer system is on a regular basis either outdated or has incorrect information. So they didn't understand it was associated with a female. They were only making an assumption based off their generally outdated and incorrect computer database.
Ultimately, after talking to Dan for some time, the police were able to satisfy themselves there was no need to press forward into the residence.
Translation: Dan knew his rights and schooled the police, and they realized what they were doing was wrong.
Dan was subsequently. Charges were submitted to Crown. Dan was arrested on a warrant sometime thereafter. He was released on a recognizance of bail dated.
What was he arrested for?
Assault.
And how did that get to them? Because it's the accused that calls them to the building.
The complainant made a separate report of the incident to police, and the police, upon comparing their interactions with Dan and that of other witnesses, ultimately decided to recommend charges to the Crown of assault.
Oh, wait a sec. Hang on a sec here. Lorne T. Phipps, Crown Prosecutor in Victoria, British Columbia. Did you just say the police had interactions with other witnesses? Wouldn't that lead the judge to believe that there were other witnesses? And those other witnesses gave some information to the police that was creditable, that discredited what I was saying? And could possibly validate what Mr. Pooh was saying? That's what you're telling the judge, right, Mr. Phibbs? Mr. Phibbs is fabricating evidence right here, right now, because the other witnesses that he's telling the judge about that police had interactions with, they don't exist. There's only 2 people mentioned in this police file, Mr. Pooh and me. So there are no other witnesses. 0, none, do not exist. But if the prosecutor, Lauren T. Phibbs, is telling the judge that police had interactions with other witnesses and they decided to recommend charges, is that misleading a judge? Is that fabricating evidence? Yeah, subsequently charges were submitted to Crown. I believe it was 4 months later, after I'd had a phone call with Constable Ron Kirkwood about the file. Then I told him he was wrong, and then there was a warrant for my arrest.
Dan was released by consent on a recognizance of bail in the amount of $1,000. No deposit, no surety. Conditions included that he not have contact with the complainant, Mr. Pooh, to not attend at his residence, workplace, or school.
Mr. Phibbs also puts it to the judge that in my bail conditions, I'm not to be at Mr. Pooh's residence. Well, that's not what it said on the bail conditions. It said on the bail conditions that I cannot go where I know he lives. So the judge is now under the impression that I've been told not to go there via the bail conditions.
The next important event chronologically is that this matter began before your sister Judge Rogers on August of this year. In the course of the trial, Mr. Pooh was sorry. In the course of the trial, Dan was acting for himself and had the opportunity to cross-examine the complainant, Mr. Pooh. He began his cross-examination by putting it to Mr. Pooh that he lived at Ding Ding O Ding Up Hill Avenue.
Right, and I put it to Mr. Pooh because the Crown disclosed that information to me. Something Mr. Phibbs has left out, misleading the judge.
Similarly, in the course of cross-examination, Dan put it to Mr. Pooh that Mr. Pooh lived half a block from where he lived, that Mr. Pooh's wife and children lived there, and that Mr. Pooh was fearful of Dan. As I say, Dan put all that to the complainant. He then put to the complainant that he walked by the residence on an ongoing basis, and that the complainant's wife, infant and toddler still walked by Dan's residence.
And Dan put all that to the complainant because he's representing himself, which means he gets a copy of all the statements that Mr. Pooh wrote to the police, which means Dan's read them, which means Dan is going to ask questions about the exact statements that Mr. Pooh made to the police. So the questions that I asked Mr. Pooh basically mirrored his statement. So, for example, Mr. Pooh would say something about being fearful in his own neighborhood. I would ask him a question about being fearful in his own neighborhood. And it's questions like this that I pulled out of Mr. Pooh's statement, which actually went to discredit him because in the very first statement that he wrote to police, he said that after he was assaulted by me, that he called out to me to, quote, "Come back," unquote. So what I was doing was I was pulling questions out of his statements. So if he said he was fearful in his own neighborhood, I would take that statement and make it into a question at the trial. So I would ask him a question like, "Are you fearful about being out in your own neighborhood?" And he would answer yes, or something like that. And then I would ask him, in your original statement to police, you said that after you were allegedly assaulted, you had called out to me to, quote, "Come back," unquote. When you called out for me to come back, were you fearful about being in your neighborhood at that time? And then he made statements to police that he has young children and a wife with a baby on the way. And he said he was concerned about, their safety too. So because I read that in his statement, I asked him a question about that at the trial. And it was something like, "Are you concerned for the safety of your children and your wife who's got an infant on the way soon?" And he would answer yes, or something like that. And then I'd ask him, "So after I allegedly assaulted you and you called out to me to come back, were you concerned for your children's safety and your wife's safety who has an infant on the way when you called out for me to come back?" All these questions that I'm asking him are based off the statement that he wrote to the police. But what Mr. Phibbs is trying to do here is he's trying to put a spin on it. So it sounds like I've been like, monitoring or like surveilling people, and I'm like, oh, there's so and so. Yeah, so now I'm going to ask him in court about that. And this is, again, intentionally misleading the judge. So what Mr. Phibbs is trying to do here is he's trying to use the questions that I asked Mr. Pooh that were actually based off his statements to police. He's going to try to make it out that because I asked those questions that I knew what Mr. Pooh's wife and children look like. And Mr. Phibbs is doing this to intentionally mislead this judge.
Now all this is significant as we come to the events of August 2016, and there are the events set out in the information. So, as I say, the trial before Judge Rogers begins on August, and it was scheduled to continue August. The parties come back. They're in, they can't begin immediately, and at 11 a.m. Judge Rogers asked the parties to reappear in court and tells them that they won't be able to get on that day.
Oh man, here we go. Mr. Phibbs just fabricated more evidence. He just told this judge that on the second day of trial, we were called back in by Judge Rogers because we can't begin right away, and that we'd have to continue this matter on another day. But that's not what happened according to the transcripts at the end of part 2, when we spoke with Judge Rogers for almost 10 minutes about how Judge Rogers already knew it wasn't going to continue the next day and what we should do about it and how we're going to go about it. Judge Rogers even tells me, don't bother bringing anything except your calendar. And then the very next day we show up to fix a continuation date, which we did, but that's not what Mr. Phibbs here is telling the judge. What Mr. Phibbs is telling the judge is a lie, and it's fabricated evidence.
And they're directed to attend at the GCM's office to pick up a scheduling notice for the continuation date. Once out of the courtroom, Dan did not attend to the GCM's office. Rather, he purposely, in the words of the witness, stormed out of the courthouse, and he must have proceeded almost immediately to the residence of the complainant, because he is alleged to have been there at 11:30, a half hour after the appearance before Judge Rogers.
Now, Mr. Phibbs says I stormed out of the courthouse, according to a witness, which is odd because the only people in the courtroom were the judge, Paul Cheeseman, the Rent-A-Crown, myself, and maybe a sheriff or two, maybe like one other crown sitting in the seats behind us. So I don't see how any of those people could really be a legitimate witness to anything. A biased witness, maybe. Now, Mr. Phibbs says I went immediately to the complainant's address after leaving court, which is hilarious because that's half a block away from where I live. Remember how he said I went home after that hearing? So Mr. Phibbs is misleading this judge.
As I say, at approximately 11:30 in the morning, the complainant's wife, Mrs. Pooh, called 911 to report that she observed the accused filming her and her children with what looked like a cell phone at the parking garage of her residence on Ding Ding Zero Ding Uphill Avenue.
Mr. Pooh's wife and children, eh? Oh, wait a sec. They live there? How can they live there if Mr. Pooh interrupted my questioning the previous day about how he lived there and how he started answering questions with things like, where I lived at the time? So now they live there?
She first noticed Dan when she observed him press right up against the parkade gate filming her and her children.
That's a bunch of BS. Never happened.
When she pulled out of the parkade, Dan was now waiting at the top of the ramp filming her again.
And that's a bunch of BS. Never happened.
And that's when she decided to call 911. Police attended at Dan's residence in response to this complaint, him having been observed to retreat to that location. Dan answered the door with a camera attached to his head and his court order in hand.
And that's a bunch of BS, because that's not how it happened. I answered the door. The police told me I was under arrest. I asked if they wanted to see my bail conditions, and when I came out with my bail conditions, that's when I came out with a camera on my head, not when I answered the door. Total BS.
Dan was arrested by police. He subsequently provided a statement in which he said he was not breaching his recognizance, as he stated that he knew where Mr. Pooh lived, but Mr. Pooh denied living there. I believe that version of events is contradicted by the DARE's recording from that hearing.
Hey, isn't that kind of like the story I've been saying all along? Mr. Phibbs is now misleading the judge. He's saying that my version of events is contradicted by the DAR's at the previous hearing. So my version of events is that I can't be breaching the bail conditions because Mr. Pooh testified several times the previous day that he no longer lives there. But as you heard in part 2, Mr. Pooh says several times on the record, indicating that he no longer lives there. He's moved. Judge Rogers even says to Mr. Pooh, "I gather you no longer live there? Are you comfortable talking about where you were living at the time?" And then Judge Rogers instructs me to change my questions to where you lived at the time. And that's all on the DARs, the digital audio recordings of the Victoria Law Courts. And Mr. Phibbs just misled this judge, saying that my version of what happened is contradicted by the DARs. Mr. Phibbs just won't hold back with fabricating evidence while obstructing justice and criminally harassing me. And he'll say anything to mislead this judge and to use the courts as a weapon.
He claimed and as such believed he was not breaching his recognizance and was taking photos of the parking garage at Ding Ding Zero Ding Uphill Avenue for a film he was making regarding his charges and the actions of the Victoria Police.
That's BS. That's not why I was there. I was there to take pictures in the defense of my assault trial. Told the police that a lot of my footage that I've gathered is actually going to be in a documentary about the false arrest via Ron Kirkwood. This is just more things that Mr. Phibbs is putting his own spin on to mislead the judge and fabricate evidence.
As I say, given that the accused has provided a statement acknowledging that he was at that residence at that time, the date previous having put to the complainant in court on the recording that that was the complainant's residence, having stated in court that, having put to the witness that he observed the complainant walking by his house on an ongoing basis, it seems that the Crown's case and the circumstances is quite strong.
Again, I never put to Mr. Pooh that I had observed him or his wife or his kids or whoever walking by my residence. I put questions to him that mirrored his statements. And by Mr. Phibbs telling the judge that I had observed them going by my residence, he's doing this, he's fabricated this in order to mislead this judge. Yes, Mr. Phibbs, your case is quite strong when you intentionally mislead a judge by fabricating evidence.
Your Honor, in summary, considering the abstract, threats and threatening conduct sometimes doesn't really resonate, but for the recipients of those threats or that threatening conduct, particularly when that touches upon their children, their infant children and their spouses, the effect can be chilling.
And Mr. Phibbs is pulling the children card. It affects their children and as he's reading the statement, their infant children and their spouses. That's an interesting opinion you have, Mr. Phibbs. Too bad you're relying on fabricated evidence.
Mr. Poe testified before this court in a criminal proceeding, in my submission, on behalf of the Crown. There's no other way to characterize the behavior of the accused other than a naked attempt at retribution for evidence that a complainant had given in a criminal proceeding in this court. In the circumstances, there's a serious risk of harm to the administration of justice.
You want to talk about serious harm to the administration of justice? Well, you're listening to it right now. If you're watching this series, you know exactly what serious harm to the administration of justice is, because that's exactly what this series is about. It's about the words that are coming out of Mr. Phibbs' mouth right now. That's the serious harm to the administration of justice. Prosecutors that mislead judges, lie, fabricate evidence in order to retaliate against a justice participant.
And in particular, I had cause to go back to look at the provisions of 515, and it's clear that the secondary ground, in addition to contemplating a need to against the reoffending of accused, specifically contemplates the need to protect witnesses in criminal proceedings. At the time of this conduct, Dan was on $1,000 recognizance. He is before this court today in a reverse onus situation. In the Crown's submission, there is no conditions by which Dan can satisfy the court that he won't lose his temper and act out against other witnesses in the future.
Lose my temper and act out against other witnesses? What the hell? When did I lose my temper? Oh, was it the time I took a picture of a building? Yeah, that's, losing my temper. Okay, go ahead and keep misleading the judge here, Mr. Phibbs. Keep fabricating evidence. Go ahead.
And in those circumstances, it's the Crown's submission that he should be detained.
Just so I have this clear, counts 2 and 3, are they related to his filming the family?
Yes, Your Honor.
So nothing verbal but goes to the, they live in an apartment or something?
Yes, Your Honor.
And he's filming what? The apartment or?
He's keys. My understanding from the RCC is that the woman and 2 children are in the parkade.
Oh, here comes the parkade BS again.
They see the accused pressed up against the gate of the parkade holding the camera, having it directed at them.
How is it that I could walk out of a court hearing and decide to drive right to Mr. Pooh's residence to film his wife and children who are in the parkade, who I have no idea what they look like, I have no idea who they are or where they would be, and I just show up out of nowhere and decide to film them, and they just happen to be in the parkade, and I have no idea who they are or who they look like? How is that even possible? All half a block away from where I live.
There's some. I believe the complainant calls out to Dan. Forgive me, Flora.
That's fine.
I don't want to misstate this.
I don't want to misstate this. Mr. Phibbs, you've misstated just about everything you've said out of your lying mouth.
So Miss Pooh was in the underground parkade with her children when she noticed a male up against the parkade gate filming her and her children. She said to the male, "Excuse me," with no response from the male, but realized he matched the description given by her husband of a male who had assaulted him the previous year.
Hang on. The male that had assaulted him the previous year? That's still before the courts, sir. And here's a little update for you. I was actually found not guilty, which is pretty hard to do when you don't have a lawyer. So maybe the allegations were so hilarious and bogus, and there was no evidence that maybe this should never have been brought to court to begin with. Just more lies from Lorne T. Phibbs. Fabricating evidence, obstructing justice, and criminally harassing me. You're hearing it right here.
And then appeared in court in relation to the assault the previous day. She got in the car with her children, locked the door, called her husband to confirm it was the same male.
Lock the door, quick! It's a guy with a camera! He's gonna lose his temper and take a picture of our building, which we no longer live at!
While she was on the phone, the male left and walked up the ramp, at which time now Mr. Pooh was apparently able to identify this as the accused. At this point, Mrs. Pooh called 911 because she pulled out of the parkade and the accused was waiting at the top of the ramp filming her.
Yeah, just waiting there filming her. Someone will have no idea who she is or what she looks like or where... Wait a sec. They live there?
So the trial didn't complete?
No, my understanding, and I defer to my friend, but I believe the trial is set to complete on Wednesday this week.
That's correct, Your Honor.
Subject to any other questions, those are the Crown's submissions, Your Honor.
So due to the length of time on this, I'm going to conclude part 4 here. Please leave a comment below on how you think Mr. Phibbs is handling this case. And be sure to check out part 5 as Mr. Kuzma for duty counsel will start my defense as part 5 starts. Thanks for watching.